I can.
Okay, perfect. All right. Good evening, and I want to thank you all for being here. Tonight is a powerful and necessary conversation, one that many people delay, avoid, or simply don't fully understand until it's too late. So, tonight, we're talking about the importance of wills and trusts, not just as a legal document, but as an act of love,
Mhm.
responsibility, and legacy. Planning for the future isn't just about assets or finances. It's about protecting the people that we care about, honoring what we worked hard to build, and making sure our wishes are carried out with clarity and dignity. A will and a trust gives you a voice, and when you're no longer, for pretty much when you're no longer in the room. So the conversation tonight is about empowerment. It's about taking control, creating peace of mind, and ensuring that your family is not left with confusion, conflict, unnecessary burden during such a difficult time. So, no matter the age, income, or stage in life, this matters because legacy isn't just what you leave behind, it's how you prepare those moving forward. So let's lean in, learn, and take steps towards securing not just our future, but the future of those connected to us. So, without further ado, I'll announce our guest speaker, April. And thank you so much for taking the time out to come and educate us on the importance of having those advance directives and having a will, because in honor of Women's History Month. It's like we need to definitely take care of us first, secure our futures first before securing the others. Because what good are we if we're not taking care of ourselves? So thank you, and you have the room.
Thank you. I actually was grateful that you had me to speak. Nice to meet you, ladies. Just a little bit about myself. I am a mother of two sons. I have a 1 year old and a soon to be 11-year old, and I've been in the legal profession for the duration of my adult life. I started as a secretary at 16, moved all the way up, and now I'm an attorney and I have my own firm. Now, I know that a lot of us talking about wills, trusts, it can feel doomy and gloomy. So when I was making this presentation and I kind of pondered on Women's History Month, it occurred to me, I was just like, how can I relate to the ladies that there's power in creating these documents? So what I came up with was legacy protection and the power of being prepared. So we're going to talk about wills, trust, and advanced directives and how you can take control of what matters most now, and then it'll help to kind of alleviate a lot of the stress that we deal with. And just in terms of anything, right, as women, we have so many things on our plate, but once there's a plan in place and things are established, you can kind of free up that room and free up your bandwidth. Um, is the legacy about money or something more? One of the things we're going to talk about is trust. And this is probably one of my favorite tools. Why? Because you can create it informally. And it's also something that we can create while we're living, right? So a lot of my clients, they don't want to talk about what happens when they're dead, but they do know how they want things to happen right now. Let's say I have a child in college and I want to allot X amount of dollars to go to them as long as they maintain X amount of grade or whatever. You can have a trust set up for that reason, as little or as much as you want, living and in death. So let's say I have a trust set in place now to do all those things and I pass away. That automatically goes into effect as a will in most states. Um, Almost anywhere, if you have a document that kind of identifies what your desires are as you are living, the courts will always enforce it. And the biggest thing is you never want, a lot of people don't think about it, right? I don't have enough assets, or I only have X amount of dollars. I don't own any property. Yes, you do. If you think about the fact that, let's say you were to disappear tomorrow, would your family be prepared to carry on as you probably would like for them to be, or would they be left scrambling in a probate process that's actually costly. So you could lose much of your estate just in court because you didn't leave a document behind. So to distinguish, wills are something that you use to protect after you die. So that's something you would go and you would say, hey, in the event that I pass away, I would like for this to happen. And let's say you rent your apartment, but you have a dog, you have a house, you have some designer bags, you have just things. I want my sister to have my purses. I want my son to have the car unencumbered, those kinds of things. And you can write it in plain English. A lot of us type in notes. I would challenge you all, if you find that you do something on a daily basis or you're a support to another, to just compile in your notes what you want to happen. Um, for my son, he gets $15 on green light weekly allowance, right? So I would say Josiah to maintain weekly allowance in custody of whomever takes him or whatever. And you just type it in your notes. And I've seen things as informal as that act in the absence of your presence. The trust that I mentioned a little bit earlier, it protects during your life and beyond. So you can use a trust to maneuver. A lot of wealthier people use trust to actually protect their assets. So I'm liable to a suit, or if creditors come after me, they can't protect this asset because I've put the house in my son's name, or I've put those diamonds in my son's name. So if anything were to happen to me, those assets are protected through a living trust. That those are just examples. And if you pass away, obviously those trusts become irrevocable, but those are the easiest to use. Advanced directives are also extremely critical as women, especially because a lot of, as we all know, our voice can be heavily muted, is the word I'll use in healthcare. And so having an advanced directive ensures that your voice is never legally muted. And furthermore, if you do have a next of kin, it may be that you've never had a conversation about that with them, about what you would like to have happen if you were on life support. Maybe we never got to that conversation. They could just refer to this document. And again, these are all things that you can create simply. A lot of people think that it's going to be expensive. It's really not that expensive, and it's actually not as formal as you think. Again, there's so much power in just having slight preparation in place to protect the ones we care about. Um, so then I'm going to touch a little bit on these. I'm not going to go too in depth because it's obviously they each have their own spins and things that are different about them. But I did want to just touch on what happens without a plan and who decides if you don't. So I mentioned a little bit earlier, there's a probate process. So let's say you pass away and you have no will. There are different laws in each state about how your property is directed, and that property takes does not take into account what you want at all. It's just by law, your spouse gets this, your kids get that, and even sometimes creditors can become intertwined with it, all because you didn't create a document. So you could lose assets, you lose certainty, you lose authority, and you lose the ability to communicate with your loved ones in a way that can help them during a time where they're obviously they would be either grieving or you would be otherwise indisposed. So you could still be there for them in their time of need in a way. And then, so I put something in my presentation about just pausing and reflecting because a lot of times when the information is coming at us in the way that I kind of tend to deliver it, it's hard to put it into perspective. So if something were to happen tomorrow, would your family be protected or would they be left figuring it out? Clarity is a gift you can give to them today. You can each do it today. How do I do it, Attorney Jones? I'm glad you asked. Your next step, you can create or update your will. Listen to me, ladies. This does not mean you have to dust off your MacBook or your laptop or have even more than 5 minutes. This is as simple as when you take a moment for your self care, right? Because this is also a form of self care. You can sit there and think, my daughter, I want her to have X, you know, a lot of us have life insurance plans, so we're not really concerned about the money. But let's say that you have an heirloom, a family heirloom that's jewelry, or something of importance to her that you all share. I'd like for my daughter to be able to use my white Benz or my Lexus truck in my absence, right? I'd like for her to have continued use of this truck no matter what. Um, I'd like for my son to continue to receive an allowance during college as long as he maintains X. I'd like for my husband to take over all of this and do as he see fit, period. It's that simple. Anything that can outline your true wishes, if the court can construe it, they will impose it, they will execute it. So that doesn't even mean you need an itemized list. Some people will think, oh well, I don't know everything I have, I need an itemized list of everything I have. No, you don't. All my stuff, give it to my husband, he'll know where it goes. Give it to my sister, she'll know where it goes. Give it to my son if he's above 18. Give it to, it can be that clear. It can be that concise. And then it's as simple as transferring that document to a Word document and getting it notarized. If you don't have the money or the desire to invest your money in an attorney creating a fancy document, because a lot of people think the more expensive the attorney and the fancier the document, the better it is. No, the clearer you can express your intent, the better it is, actually. Now, as if you hire an attorney, we're able to kind of create the trust in such a way, create the wills in such a way, but it's not about the protection part. The protection part you can do on your own today. Um, And then my kind of final thoughts were that legacy isn't what you leave behind necessarily. It's what you protect while you're here, and preparation is where that protection begins. So I encourage you each to start with just one document. And that's all I have, but I am going to open the floor up for questions.
So I have a question. Pretty much you're saying that a document, a will, only has to be notarized to be legal, a legal document.
That's exactly what I'm saying. Well, I practice in Texas, so these laws primarily are governed in Texas, but universally speaking, if you have a document that identifies what you would like to have and you have nothing else, it will be construed as your will.
Okay,
So,
so it has to be taken off of the Word document on our phones and put into paper and signed by and notarized by a person.
correct. And if you go, so let's say I create a note, you can literally share and email it to yourself. You can, it's very simple, but yeah, you email it to yourself or put it in a Word document and you get it notarized and boom. If you never go get a real will done, they will use this as your will if something happens to you.
Okay. So, one more thing before I open the floor for questions. After we answer the questions that they have now, can you touch on the document that you sign at the bank? Like we can walk into the bank and say payable upon death or whatever.
Mm-hmm.
And then the other one is how to monopolize on a trust.
Okay.
And that's after the questions about the wills.
Okay.
So anybody else, feel free to ask questions.
I just want to collaborate on trust as well because I'm trying to figure out how do I become someone's trust.
So you mean to be the person who is the trustee, like you're receiving something from the trust?
Yes.
So the grantor would essentially establish a trust for you. So the person that wants you to receive whatever benefit would establish it in the form of a document and in the form of practice. So it could be, let's just say money because it's the clearest example for all of us. you're to receive $1,000 a month. In practice, that looks like receipt of some kind of allotment or recurring payment. In document, it could be something as formal as an email with a disclose, or as informal as an email, and as formal as a contract. I've seen them play out both ways. And especially now in 2026, trust people are establishing trusts in practice and not realizing that if ever litigated, those trusts are actually construed the same as some trusts that are established by paper.
Mm. Okay, thank you. Oh, and is it a certain age now for myself if I wanted to make, like, say, my grandkids my trustee?
Yes, ma'am.
What is
You
that?
mean you can bestow the benefit upon anybody of any age. Um,
Mm.
there's not a parameter. Now, what you cannot do is impute a legal, like if there's a misnomer, I want my son to make all my decisions, or I want my son to exercise authority over this asset, and it's obvious that your son is a minor, then you can't do that. But most people use their common sense when they're creating these trusts because they are usually ongoing during life. So usually trusts are fleshed out pretty clearly.
I have a question for, I guess it's more or less a will. If you already have a will set up in place and say you and your husband get a divorce, but does the will get done then too? Or do you have to go to court to have that delivered, like taken off? Or do you have to get it notarized that it's taken off? Or because you got the divorce, it's kind of null and void?
No, no. So it's not null and void. That's the
Okay.
danger. Once you create a will, your last living will and testament is what the courts are going to construe as your ongoing wishes. Because think about it, just because you got a divorce doesn't mean that that's not the person you trust most with your assets. So that's why you always want to create something that's clear. Now, maybe you, in a lot of my family law cases, maybe it's not a point where they are able to afford to get the will redrafted, or they just don't want to yet. They haven't healed that emotional wound.
Okay.
What they can do then in that case is write down a separate document. A separate document under the UCC can be taken together with your original will, right?
Okay.
Post this big dramatic life event, divorce, right? You have
Mhm.
another document. Let's say your journal. Let's say your daughter says, "Hey, my mom never changed her will, but I was reading through her journal, and it says right here that she wants dad to not have this, and she wants me to do it instead." The
Yeah.
court will take those two documents together. They will decide whether they're authentic, obviously, and then they can also do it that way. They could take into account the latter written, more recent document to determine,
Okay.
okay, she obviously didn't mean. But ultimately, the court with a will is trying to get at what was your intent.
Okay.
So is that within, like, would that happen now, or would that happen later on when she succumbs?
The interpretation, a will doesn't matter until you're gone. So the interpretation issue wouldn't arise until she would succumb
Okay, so the
Okay.
journal paper and all that would happen later.
After.
later.
Or she would
Okay.
need
Now,
to go take it back to court, right, if she wanted to do it now.
if she wanted it now, well, I want to be clear. Your will doesn't govern anything now, today, while you're living. That is not a will. A will is specifically for after you pass, but you can prepare it now. A trust, I think, might be what you're referring to, right? Um, and that is what is interpreted now, if that makes sense, because regardless of her divorce or not, her will still never came into effect because she never died. So
Okay.
the court doesn't interpret it until you actually pass away.
So would, I'm asking for my mom. So if, since she got the divorce, the will and some of the items that were on the will we've sold now.
Hmm.
So that would that just basically be null and void then? Or do we have to
Okay.
have a separate document writing that out, stating that?
In a perfect world, you have a separate document. That's the cleanest way to do it, right?
Okay.
I am speaking today more so toward the practical way to do it, but the cleanest way to
Mhm.
modify any legal document is with a new legal document, right? That
Okay.
directly
Yeah.
addresses the modification. That's
Okay.
the cleanest way to do it. However, if she were to pass away without a plan, a multitude of things could happen, which is why you want that plan to be in place. So if
Exactly.
my advice to her would be that if that will that she has is
Hmm.
not her intent moving forward,
Hmm.
then I would advise her to amend it ASAP, because a
Okay.
court will most certainly implement your will in exactly the way that you wrote it. I
Okay.
used to
Okay.
do a lot of probate, and you would be surprised who comes to collect. And it's like you and this person just had this big, huge fight. Y'all haven't spoken in years. You haven't, how did you even learn that they passed away? And they are there to collect. So that is why you protect your family, your loved ones, your assets, and most importantly, yourself. Because if you wouldn't give this person $200,000 right now while you're living and breathing, why on
Hmm.
earth should they appear 30 days after your demise demanding payment of your under your life insurance plan because you never took them off? And so a lot of these
Exactly.
things
Okay.
are just a way that we take care of ourselves just moving forward, right? Like I want that money to go to my children or my grandchildren
Yeah.
or a nonprofit of your choosing, anybody but you. Imagine your cheating, lying ex-husband receives your document, your hard-earned retirement, your
Yeah.
TSP, whatever you have, because a lot of us put into retirement and don't even realize how much that is. Imagine your whomever, your estranged, child, whatever you have going on, and that person is the person who inherits because you didn't have the time or you didn't think that it was important enough for you to draft a document. We all have something that someone will want to inherit if we pass on. And so it could be as simple as establishing someone to act on your behalf, right?
Yeah.
I want my sister to do it. I want my brother, and if she's not alive, I want my brother to do it. And if he's not alive, I always say do at least the first three, because after three, we're picking and choosing, right? So just do
Yeah.
your at least first three, right? And
Okay.
that way, if you pass away and your sister's already passed and you forgot to, you fell into a depression, you didn't, they already have what you wanted to happen if your sister's not here. And
Understood. Okay.
um, one of the most recent um things that I had happen was a lady's stepchildren who she'd taken care of as her own could not inherit because she did not adjust the life insurance paperwork. Um and she
Yeah.
didn't have anything in place. She's taken care of these stepkids her entire life.
Hmm.
When she passed away, they were all receiving benefits of various different degrees from her, and they weren't able to collect anything under the will. Luckily, because she put her husband in place, it was her husband who had to act in on her behalf. But not everyone has a husband who would even, do that. But it was his kids, so obviously it's in his benefit to make sure they're good. But it doesn't always work out that way, and a lot of times it doesn't. And people never think about that. This is our way to make sure they're good, even when I'm gone. You're, and it frees up a lot of space in our mind. It actually frees up space for us to put us at the front and center, because you can kind of live a little bit more unencumbered. Like, I've already taken care of them. I've already made provisions for that. We don't stress about dinner when we know dinner's already been in the crock pot all day. We don't stress about the time to do A, B, or C thing when we already know, okay, I put it in the GPS. I'll be there 15 minutes prior, and then that'll leave me time to go pick up little Billy. You don't stress when you have a plan in place that works. You
Hmm.
stress and you worry when there's no plan in place, or when there's uncertainty or ambiguity or the unknowns. So reduce those as much as you can by just creating these little documents. And especially, I can't stress to you all as women, the advance directive is the one that gets overlooked the most. And I think it's by far the most important in this political climate right now. Just everyone has a say about what happens with uterus, even people who don't have a uterus. Your advance directive is your protection. And, I would encourage everybody to at least make sure they have one. And most times, if you are, competent and alert when you enter the hospital, they'll give you an opportunity. But when you need it most, you're not alert. You're not even conscious. And so you want to have one of those as well.
You
Don't
said
overlook those.
you said they give you an opportunity. At what point? Is it at
You
check-in or
They will give you, so let's say you come in critical condition. They don't usually give it to you, but in those big forms, when you get admitted to the ER, within there is an advanced directive, and it'll say, I do have an advanced directive. I don't have an advanced directive. I would like to. In Texas, they ask you that. Do you have one? Do you not have one? And then there's just a little blank space right in there. If
so
you
it's
are
best we
competent and
always
able,
do it.
it's best you always do it. And if you don't have one, um you can always say, you can write it at the hospital too, like in front of someone, a witness. If you don't have a notary, it's that informal, people. And the reason why this is a subject actually close, near and dear to me, is because you're going to work your whole life, and when you leave, you're leaving something behind, and it's only right that you have a say in what happens to those things.
Okay. So now what about the payable upon death thing? Like how important is that? And is that just for the bank?
Yes, that's just strictly a banking document. um Typically, if a promissory or someone walks into the bank and tries to do this, there are actually paperworks that each bank now has that we're all that you can ask for. Hey, what documents do I need to have for someone to access my account, post-mortem? They actually have those documents, and depending on who you bank with, they may be able to send you them on the app, on the banking app, to
Wait,
even
can you
download.
explain what that is though?
It's a promissory note, essentially. In Texas law, that's how they construe it. And essentially what you would do is you would take it to the teller of the Welby Bank. They would give you all of the assets on the death of the grantor, right? You would be entitled to all of their assets withheld and within the constructive custody of that bank. The way that I see it imposed, that includes the safety box. Every state is different. I do have to give that disclaimer. That would include also your lock safety box, but those aren't usually done that way. As I've seen it, I'm kind of a new school lawyer, so they don't do them that way anymore. Um, but they do them. Like a lot of older people with larger assets and heirlooms and things dispose of them that way, and they only want these items to be liquidated upon their death.
Okay, so pretty much it's like if I had a bank account and well, all my bank accounts, I just go up in there and give them a document and say, hey, upon my demise, I want such and such to be in control of my account.
Yes, and
And
they
the
usually
bank
have that. They will usually give you documents they have, because they have lawyers in house that have already drafted these documents in such a way that protects the bank when they act on your behalf. So that document is going to have the language you need and the language the bank needs, that protects you both and allows your loved one to actually get what you want them to have without all the hoops. Because a lot of
oh,
times, what you were referencing, I'm sorry, people do those on their own, or you have a civilian attorney do it. And then let's say I take it to Bank of America. Well, Bank of America isn't going to do anything with this if it doesn't have their language in it that protects them as well. They're going to say, yeah, go to court. We need a court order. And now you're in probate, which is what you wanted to avoid. So most of the time, it's easier to just do what the bank wants.
and do you recommend that everybody should have one of those on file, or is that something that's like Dewey Decimal System old?
Well, I think asking your bank for the document, or a lot of times they'll tell you you can just put them on there as an authorized user. They'll ask you to do it that way too. I think those are the more practical ways. But if you have assets that are unique, right? I think that you do need something that, like what you mentioned, Shonda. That's what it's usually for. In the instances that I have come across them, which are few, it's always been an item that's particularly unique, either inherited or of extreme value, and they want it liquidated only upon their death. It's not listed in any other documents. There's no other place that it's disposed of, and you remit this to whomever it's in the custody of. That's when I've seen it used most.
Okay, fair enough. So my last thing would be how do you monopolize on a trust? I know because for example, I bought my house from a trust. And I know other people, other cultures, like they buy and sell stuff in trust all the time. And it's something that I don't see in our culture a lot, where we just put all of our eggs in a trust, which I think we should, but I don't
Mhm.
have the education on that. So maybe in short, you can tell us like how to monopolize on the trust.
I can't tell you that in short. I'm gonna be honest with you because it's a lot of loopholes, right? Because the trust I think you're talking about is the one that protects wealth, and it protects
Yes.
from secured creditors. It protects from essentially anyone other than a family member. It, it, I think the perfect word would be encapsulate. It encapsulates the family's assets in such a way that if all of this goes to HE double hockey sticks tomorrow, our assets are still protected. Someone could come and sue Shonda, but she's left her loved one, or she's left her items, excuse me, in trust. So when they sue her, she's judgment proof. I'm broke, baby. And you see a lot of the rich people say, I don't have it because they've put their assets into trust. Now, how you do that depends on the kind of asset you have. That's why I can't tell you how exactly, because real estate is different from liquid cash, is different from gold, is different from, it's all different, but I would also say that it's one of the least expensive things that you can do because it's revocable. It gets more difficult to do things when they're not revocable. And the difference is just means you can't take it back, right? A trust in any form, right? You can always revoke while you're living easily. Um, so it's easy to establish, but the kind of property that you're trying to protect is where the difference comes in, or the kind of asset that you're trying to protect. But you
So,
also need to be like-minded with the individuals that you share the trust with, because someone will have more authority than everyone else. There must be a grantor. There's not a grantor and a co-grantor. There must be someone who is in charge of the trust. And so there is a lot of trust that needs to actually happen, because let's say you're in charge of the trust and we upset you, you could legally cut us off.
oh
So
wow.
so our assets are now yours. And that's, I think, to bring it back to why we don't see it in our community, I think it's there. Um, we have a lot of fractures, typically, culturally, we do, as opposed to a lot of like families where you're not going nowhere. It doesn't matter how toxic it gets, you can't go. Like, this is your family. Our assets are here. Our lives are intertwined. That's just what it is. And it's easier. Also, if you have someone that had property way back when, they were establishing those. It's a historically used tool too. Our ancestors, or many of our ancestors, didn't have anything of value to leave behind. So a lot of families have inherited these trusts, and it's been passed down from generation to generation to generation. And that's also why it's used as a tool, because when it was originally established, it was almost judgment proof. It was so easy to create this. Well, you can't come and take my horse because that belongs to the family trust. So that was the kind
Mhm.
of thinking that happened back then. Whereas a little bit different now, but actually very good question. And I think you all should kind of just create an asterisk next to what she just mentioned. Because I know, as an attorney, when I established my business, the first thing I did was create a trust for
Mm.
my personally earned assets. Because if you sue me for anything, I don't have to have fear and stress and anxiety that we're going to lose the family home. Now you're just
Mm.
coming at the business, and the only assets you can touch are the business's assets.
So, what's that other thing that they say is either a trust or this to where they can't come behind you, they can only come behind that? Is that a trust that I'm saying, or is it
It's a
something
tr-
else?
it's a trust. I think what you're referring to is an irrevocable trust, which is the form of trust that you cannot take back. So a lot of, depending on its contents and the substance that it's speaking about, then you can't revoke a trust.
So
Eh,
you're saying that if we own a business, our business should be the owner of the business should be a trust.
Not the owner. So you, the human, you, the person, you, the woman, as the business owner, you need to create in yourself a grantee. So the business, the entity creates within you, the person, a grantee, and you have property that is separate and apart from that business now. That not only has it just been moved from a business account to a personal account in the way that we, transfer cash, it's also protected from creditors and judgments against the business. So what you've essentially did is create a wall between the assets that the business has and the assets that you have as a person, as a woman, the assets and liabilities that the business is responsible for, and the liabilities you have as a woman, if that
Gotcha.
makes sense.
Okay, yeah. So, and that is something that has to be done by an attorney.
Yes, you would need an attorney to ensure that it's done properly, but usually an attorney can tell you how to do it. They'll give you a very fair quote, and it's much less expensive than any kind of lawsuit or anything like that, because as your business grows, your business becomes more likely to be sued. Let's say you go viral tomorrow or whatever. All of a sudden, there are money grubbers, and you don't know when your success is going to be triggered either. You don't know how you're going to find success. You always want your business to be insulated. The first thing people do when they get a large sum of money or access to any kind of currency is protect it, right? They put a hedge of
Mhm.
protection around it. The best way to do that is a trust, hands down. And the money that you're going to spend to get one created, it you get it back in tens of thousands. I think like tenfold is what I meant. Yeah, you get it back tenfold.
What's a typical amount, a cost for to create a trust?
Um, and it ranges, but usually there are some attorneys that will charge you their hourly rate to create it. And I can't speak to a lot of fees, but if you're looking for something solid, I think that they should be starting around 2000, and they can range upward from there. But between 2000 and 4500 is usually what you're looking at, depending on your assets. Now, if you say, I just need to get rid of my fridge, my purse collection, and my two cars, you're not looking at a $2,000 document, are you? You're looking at an hourly rate. So if that attorney's hourly rate is 380, you pay them 380 for the 3 hours it took them to create the document. And then y'all have a conversation. You pay them for the time you have that conversation, and you're done with it. And that's usually how most people get their documents created, because I just need an advance directive, or I just need a will really quickly, or I just need
Mhm.
something to put this in trust really quickly. But if you do your entire estate at once, and then you're looking at that amount. I recommend you do your business. You have items. So first you have your business, you have your personal separation, and then you have to think about your family assets as well, because that creates separate property, right? My business paid me, the person. This is all mine. This is my separate property. Now, how am I going to commingle this separate property that is now separate from that business with my family property? Because the way you dispose of family property is also different. You don't dispose of grandma's house the way you dispose of your house, that kind of thing.
Mhm. So it has a
Now,
lot. Oh, go ahead.
sorry, with the trust, because I had a trust when I was a baby and I had to pay estimated taxes on my trust. Now, do
Mm.
you still have to pay taxes and everything on your trust, correct?
If the person who created it doesn't pay the taxes on it, then yes, it can roll over to you in intestacy in the form of a gift tax, or depending on your state, how their Uncle Sugar is always going to get theirs. So a
Understood.
lot of
Yeah.
people keep but the best way to protect an asset from being taxed is to keep it in trust. Usually, what happens is people take things in and out of the trust, and
Mhm.
the assets come over, go back, come over, go back. Well, every time you do that, you're going to pay a tax. You're giving them a chance to get their bite out of the apple. So the people that benefit the most are people who put items or property or assets in trust, and they remain there, and they go, and it passes on to each generation, and they've
Mhm.
established a trust that functions in and on its own, and so it can
Okay.
always grow. But yeah,
Well,
you had
I
to pay
just
taxes because they didn't pay taxes. They didn't. They may have not have known that there would be a requirement,
yeah.
or if it was something that had to be removed from trust in order for you to gain a tangible benefit, you paid the
Mhm.
taxes for that.
I just lived off of the interest from my trust fund.
Yeah.
So every year or every month, I got a $870 check.
Ex-
So I didn't, that was just the interest. But then when I cashed it all out when I turned 21, I had to pay a huge
so-
estimated taxes on it. But I didn't know that because I didn't know any of this
Yeah, it's because you withdrew everything. So you
from there.
essentially closed
Okay.
the trust. When you close the trust,
Mhm.
now it's taxable. Remember what I said. If you keep
Yeah.
it insulated in that trust, it's judgment proof, it's tax proof. Even when you were just
Okay.
grabbing bits and pieces from it, but you maintain something within the trust, no taxes. So you continue, and that's why I say trust can get really complex, but it can be as simple as I send an allotment to my son of $100 every month. He gets an
Okay.
allotment. So that's clearly I've established a trust in practice.
Okay.
And just a lot of people, most people actually just don't have the time. They don't take the time. We all have the time because we all get on our phones. If you look at your screen
Mhm.
time and you see anything other than books and productivity on your little graph, that means you have time to go into your notes and type up some stuff.
Very true. So if
Let
I
me go
see too
look at
much of
my screen
Facebook,
time. Oh man.
okay, good.
Okay, sorry. All right, Michelle, that was all your questions.
Yes.
Anybody else have any questions, comments, or concerns? Okay. Well, April, tell us where we can find you if we have any other questions that we want to ask.
Yes. So jonesforjusticelaw.com. Or you can, I don't have my social media up and running, but if you have any questions, you can email admin@jonesforjusticelaw.com.
Let me
And
put it in the comments. You said admin.
at Jones for Justice Law.com.
Okay. And then what was the website?
Jonesforjusticelaw.com.
Just for clarification, four is spelled out right.
Yes. I saw it when it popped up. Yes.
JonesForJustice.com.
Jonesforjusticelaw.com.
Oh, darn. Okay.
It's the same as the handle on the email. So if you email me, usually I'm able to get to emails within about 12 hours of receipt. Usually quicker than that, especially like if it's a time where I'm up and alert, I'll shoot an answer back to you guys. My firm just made its year mark, so I am my secretary and my paralegal, so you do have to bear with me a little bit, but I always get back to my clients.
Hey, well, congratulations on your own firm,
Thank you so much.
Black Girl Magic. Okay. Well, thank you all. Thank you so much for taking the time out to meet with us and educate us on wills, trust, advanced directive, and so much more. And I will definitely be in touch, me personally, because I definitely want to look into that trust. And yeah. So in this, I did record the conversation, so I definitely will be sending it to everybody on the call in case they have other questions that they might want to ask you.
And I just would encourage you guys, go on that notes app. You're gonna thank yourself. You're gonna thank yourself so much. And the way that technology is going, I wouldn't be surprised if they create some way that you can just get this spit out online. Not right now, but the way that it's going, if they continue to refine it, it'll become even easier. But courts construe your wishes if they can make them out. That's what I would leave you with. They will construe them if they can make it out. Even if it's a text that says, my son better not get nothing when I die. They're going to construe it just like that.
That's horrible. All right. Well, thank you so much. Like I said again, and I'll definitely be in touch.
Okay. Thank you, ladies. You have a good night. Thank y'all for your attention.